judge presiding. All persons having business before the court draw near, give attention to me will be heard. And God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Charlie. Good morning. Welcome to another session of oral argument with the 5th District Court of Appeal. As the marshal indicated, I'm Judge Lambert. I'll be presiding here today. We had a little change in our lineup. Judge Wozniak last week is a little under the weather, so out of an abundance of caution, Judge Evander graciously agreed to step in and take over for Judge Wozniak, got himself up to speed. So Judge Evander is seated to my right, and to my left is Judge Dan Traver. All right, we have one case this morning, case number 21-2607, Orange County School Board versus the Orange County Classroom Teachers Association. Each side will have 20 minutes to argue. I will set 5 minutes as rebuttal time for the appellant unless you tell me a different amount of time, and then I'll reset. If anybody has any type of phones or electronic devices, please put them in either the off position or mute, or you lose automatically. Oh, I didn't say that part. Or come back at 5 o'clock to get it like Judge Howard used to do in his world. Okay, if you're ready to go, counsel, we're ready to listen.
May it please the court. Good morning, Your Honor. John Palmerini, Deputy General Counsel for the Orange County School Board. Here on behalf of the appellant, Orange County School Board, and yes, it's Orange County School Board as opposed to School District of Orange County or the superintendent or anybody else. And I apologize for the error a couple times in the caption. This case comes to you all in a different posture than most of the cases you all get, because in the intervening period between the time this appeal was filed and as we sit here today, the legislature has passed a law. It is currently effective as we speak to overturn the holding of the lower tribunal in this case, in this case, the Public Employee Relations Commission. What the Public Employee Relations Commission held is that the teacher evaluation system in Florida is something that was a mandatory subject of bargaining, meaning that we have to negotiate through to impasse with the teachers union with respect to any changes we make to the teacher evaluation system. The commission changed a long-standing practice and a long-standing what the law was when it rendered this decision, because going back to as early as 1997, the predecessor to the statute at issue was 231.29, and it said...
Can I stop you right there?
Yes, Your Honor.
I just have an overarching question. I don't want to be so blunt as to phrase it along the lines of what are we doing here today, and you might correct me with the factual underpinnings of this, but we have the 2021-2022 school year is over. The 2022-2023 school year has not yet started.
That's correct.
Fees aren't at issue as near as I can tell, and we've got a statutory change. So what specifically are we doing here?
That is the exact question the school board is asking, Your Honor. We don't think we need to be here. We think this case was rendered moot as soon as the legislature passed the law.
But you're the appellant, so if you're asking us to dismiss your own case as moot, you know, you could take a voluntary dismissal, and I'm not suggesting or inferring that that's what you want to do, but it seems when you say in your reply brief and then in an ancillary way as it relates to an oral argument request in the record that this case is moot, but we also need to void the underlying PREC decision. So it does seem that you're not asking for the case to be dismissed as moot unless you've changed your position based on the governor signing this into law, and you're saying, hey, my own case is moot and I'm going to voluntarily dismiss it. If you're not going to voluntarily dismiss it and say that it's moot, what are we doing here?
It is sort of an unusual posture, Your Honor, and I understand the logic in what you're saying. And I guess I'm taking my cue from the mask case that I cited in my reply brief, where we had the controversy last year where we were one of the school districts where we required masks to be worn, and there was an emergency rule that was passed, and then the legislature came in and passed a statute that said students couldn't be masked. And as that case was in front of the first DCA, both parties jointly went to the court and said, hey, this case is now moot based upon the statutory change, we think the case should be dismissed, and we think the order should be vacated, because that was the other part of the DeSantis case and the Mass case, Your Honor. We want the order to be vacated because we want to end confusion for all of the school districts and the employee organizations of the unions in the state, because in this case, the unions may say, hey, we have the PERC's final order that says evaluations are mandatorily bargainable, and districts would all say, but hey, wait a minute, look at this statute that was passed in order to overturn it.
Right, and then based on whatever evaluation system that any individual district around the state suggests going forward, you may have an argument as to whether that evaluation system is constitutional in the first place. You may have an argument over whether it's bargainable via impact bargaining, or you might have a union basically say, you know what, this looks like a managerial right based on the individual system that was done. The trouble that I'm personally having with your argument is that it doesn't seem that you want us to give the hearing officer any factual deference, because you have a system that was proposed back in 2018 for the 2018-2019 school year that was heavily fact dependent. So I guess my reaction to what you just said is that whatever is proposed by the superintendent for the 2022-2023 school year would start its own thing. Is there something wrong with that factual supposition?
I don't think that there's anything wrong with the factual supposition. However, I think it goes into the 2022-2023 school year with a different legal background. We thought the law all along was that evaluation was a management right that we could set unilaterally. Now we have a statutory, a legislative interpretation of the previous statute that was passed through 2524 to say, yes, evaluation is a management right. So then you would go into that hearing if they were to challenge that going into the future, and they would have to say, the court or PERC, in this case, I'm sorry, it would be PERC, would have to look at it and say, all right, the legislature has said this is a management right. What is your argument to say that it overcomes the management right? Yeah, it would be a little bit different, but it is a little bit different posture than we were sitting in back in 18.
A lot of bit different, isn't it?
Yes,
I
I
mean,
think
there's
it's
a
a lot
statute that
different.
says you guys don't get to collectively bargain this thing, whereas before, apparently there's a history of the two parties collectively bargaining over teacher evaluations. At least, I mean, I know you don't, below or in the administrative body, you guys argued against that evidence even coming in, and that didn't go your way on that. But I mean, you know, I kind of have the same thought process as Judge Traver. Is okay? You're now, you have a statute that says you win, for lack of a better term, here on this issue, and now whether it's constitutional, that'll be, I guess, your opponent's fuss down the road. But right now, I mean, the statute was amended. It wasn't really a clarification, was it? Oh, it says it was amended in the verbiage.
Yeah, but I do think it was a clarification, Your Honor. I mean, the Lowry decision from the Florida Supreme Court that we cited in our materials, this is the case that fits foursquare into that Lowry, where it says if there is a legislative change that is made so close in time to the judicial controversy arising, it can be considered a legislative clarification rather than an amendment to the statute.
Hasn't the Supreme Court also said that if it lists a new effective date, that works against you, that suggests it's an amendment, not a clarification? Because why would you need a new effective date if it's a clarification?
I understand. There's the case law that the union has cited that says when it's so remote in time from the original enactment of the statute that it could not be, it would be an amendment rather than clarification. But the problem that I have with that argument is you have a statute from 1997 that says evaluation, the superintendent shall set the assessment procedures. It was called assessment up until 2011. And then in 2003, we have that PERC hearing officer saying that evaluation is a management right under 447-209. And then in 2011, it says evaluation is the superintendent shall set the evaluation procedures. All school districts in Florida pretty much understood that the superintendent didn't have to bargain those procedures
if the
up until
legislature
2018.
in their new bill said that the amendment has a future effective date, Isn't that implicitly saying that it's not effective at the time of the actions in this case?
I understand what you're saying, Your Honor, but I would respectfully say the legislature, in this case, said it was effective upon the signing of the governor. It didn't say, the rest of Senate Bill 2524, or most of it, excuse me, most of Senate Bill 2524 is effective July 1, but this particular provision was effective now. And usually the legislature, Pat, when the legislature makes any change in a statute, it's not effective until the governor signs it. So the governor couldn't say, I don't think you could say this statute was effective as of June 1, 2018.
Well, they could say this statute's been applied retroactively, or they could say nothing.
Well, I think the legislative history in this case, Your Honor, made it very clear that the purpose of this statute was to clarify that PERC was wrong in this particular case. So I think, and I've cited that legislative history from the bills.
This statute is just needed to be clarified, and it was so clear all along. Why are y'all collectively bargaining this for 16 years?
We don't think that, we disagree with the finding of PERC that we collectively bargained this for 16 years.
Incompetent substantial evidence? Because you don't make that argument in your brief. I think, in fact, you concede that while you disagree with the finding was made.
Well, and that's not to, the reason why that was done is I understand the appellate review that this court has to make based upon factual findings. There was testimony that we bargained this for 16 years. I will acknowledge that. We think the better testimony, and we made, if you remember, if you look back in the transcripts, we made a best evidence objection to the testimony because we would think that the best evidence of collective bargaining negotiations are written offers and acceptances, and you didn't see that. This was just testimony based. But we didn't want to bring an issue to the court that, quite frankly, we think this court would look at and say, Mr. Palmerini, you know the standard is if there's competent substantial evidence, whether it's testimony or documentary, we can't review that if there's evidence in the record and we have to accept it. So I did not want...
And here we are.
Here we are from a legal standpoint, because what we're arguing is if we had the management right to unilaterally change it, our previous bargaining history, I think, is irrelevant.
I'm just asking you as it relates to your statutory interpretation argument. I'm not asking as it relates to a best evident argument that you didn't make on appeal. I'm not even asking as it relates to, the factual deference standard that we were just talking about. I'm asking, how is this statute so clear so that this is a clarification if you've been collectively bargaining it for 16 years? Why would you do that?
I don't think we did, and we disagree with that. We understand what PERC held. Remember, if you look at the very first, there was 2 recommended orders in this case. The very first recommended order from the hearing officer said we didn't bargain the creation of this Marzano evaluation framework. And then PERC remanded, and there was a finding that the statute of limitations was violated by the union by not filing in time. PERC remanded and said, hey, look, the statute of limitations argument is flawed, but we're not necessarily going to accept all the union's argument. And then the hearing officer says, well, no, I do think there was collective bargaining. So the hearing officer changed his factual holding from we didn't bargain this to we bargained this. So we clearly have disputes on that, but we think, regardless of all of the factual things, Your Honor, this statute's clarification shows that we have the management right to do this. And if we have the management right to do this, this case now becomes moot going forward. There's no effectual relief that you can...
If we see it more as an amendment as opposed to a clarification, does that kind of end the vigor of your appeal or the merits of your appeal, or no?
Well, it depends on... There's 5 things that the commission ordered us to do. And so they were, I think, don't refuse to bargain with the union about evaluation. I think the statute takes care of that. And it says rescind your 2018 evaluation system that you unilaterally adopted. Well, under this statute, if let's say we don't think we adopted it. You see replete in our argument that we had the same learning map going forward. We didn't actually adopt that evaluation system, even though the hearing officer held that we did. But let's say that we did adopt that evaluation system. Going forward tomorrow, we could go ahead and implement the evaluation system because the legislature has now said...
Well, let me ask you this in that regard. If it was undisputed that the evaluation system you adopted added 2 hours a day of time the teachers needed to put in to comply with it. Is it your position that the teachers have no remedy?
What my position is they do have the right to impact bargain over what is a management right. That's that Indian River County case that we cited. Management has the right to implement a system, but we have to bargain over the impacts. And there's a case called Palm Beach County School Board that we've also cited in our materials that says workload, which is what you're talking about, Judge Evander. Workload is a bargainable impact, but is not a mandatory subject of bargaining. So their remedy, the teacher's remedy, would be going forward, they could get to bargain the impact, but it wouldn't prevent us as the school district from implementing the system.
Well, as a practical matter, though, if your system required an extra 10 hours a week of work from the teacher, and they have the right to impact bargain, how's the only way you remedy that extra 10 hours of work?
You can go through impact bargaining, and that can go to impasse. But the underlying system itself, the underlying evaluation system, is now something that under the statute is something we get to unilaterally decide.
What does that mean? Is that they, as a practical matter, have no remedy?
I wouldn't
You
say,
keep the system no matter what the impact is?
I wouldn't say that it was they're without a remedy. I would say that if we went through an impasse hearing and it went in front of our school board as the legislative body. We've just gone through 2 of these this year, and the school board has not accepted the superintendent's position in either one of those uniformly. They have given a little to the teachers, they've given a little bit to the administration. So I think they do have a remedy through impasse bargaining. I see I'm now in my rebuttal time, so.
If you want to continue, that's fine. If you want to stop, that's fine, too.
I think I'm good to stop for here.
Okay, very well. Thank you.
Good morning. If it please the court, I'm Toby Lev. I'm representing the Orange County Classroom Teachers Association. I guess I can jump in with the issue the court seems most concerned about, which is mootness. We agree that from June 2nd this year forward, we cannot bargain over the evaluation procedures, only the impact of the evaluation procedures. We think some of the PERC order concerning violations that occurred in May 2018 before the effective date of the new statute should still be remedied by the rescission of whatever occurred in May 2018. On June 3rd, 2022, the school board can devise whatever kind of evaluation system it wants and only have to impact bargain with the union. But we think that a violation that occurred 4 years before the effective date of a new statute should be remedied, especially when the new statute is not retroactive.
What does that look like practically, the remedy?
They'd have to rescind anything that they implemented in May 2018, and then going forward, you know, they can devise their own system and only bargain over the impact if that's what they insist. There would be a notice to employees, and we have to be crafted in such a way that there's no prospective duty to bargain going forward, but actions taken prior to the effective date of the new statute will be remedied, including the rescission of the 2018 changes, and the school board will not refuse to bargain over mandatory subjects of bargaining in the future without saying not refuse to bargain over evaluation procedures, just more generally. And that would be the extent of the notice, which would have to be revised.
What's the practical effect of rescinding the 2018 action?
The practical effect, there would not be that much practical effect except to vindicate a violation of the statute that occurred. Also, I would say that
What would be the vindication other than a notice saying we committed a Unfair Labor Practice Act?
well, that particular system did impose a lot of additional work, as PERC found. So that would, in itself, reduce the workload on employees that they had to do to get a paycheck and keep their job security.
But they've already done that work, haven't they? I think that's what Judge Evander's alluding to. I mean, going forward now with the new statute, however you all attack the new statute is, not before us, but, okay, so if these employees, these teachers have done the added work that was improperly required of them according to PERC,
Well, they would
then
no
what
longer,
happens?
they would no longer have to do that added work in the future if that system that was implemented in May 2018 is rescinded. Now, I suppose they could come up with a different system that imposes more work, and we can't control
They
that.
came back with the same system, says, okay, we didn't fare so well with the fifth ECA, but we got this new statute, and we're going to impose the same thing we did before, and we don't have to collectively bargain with the union anymore. Could they do that?
I think they could impose anything they want. And
yeah,
all they
they
can do
could,
is bargain over the impact. So I'd have to agree with that. I don't think they're going to reimpose what they were ordered to rescind, and I think that would be improper, but they could impose something different or worse.
So it seems to me, Mr. Lev, what you're saying, and correct me if I'm wrong, is that there is some value in the mind of the union to the precedent. In other words, you might say that you have no issues whatsoever with an unelaborated affirmance because it allows you to have that historical document that the grievance was proper. However, it seems like that's the only thing that you're arguing makes this not moot. And I'm not saying there isn't value in that, but I just want to make sure that I understand your argument.
All right, well, we hashed out whether to go forward with this, and the union president said we've sunk a lot of blood and treasure in this, and we can't just walk away from it. Our members are going to want to know what the outcome was. And in this kind of system where you have to post a notice and inform employees what happened and give them some confidence that an employer cannot simply violate the law and nothing happens, I think it's important to post a notice, and it has some value, even though, frankly, a lot of the value that this case had was gone upon the effective date of the legislative amendment.
Let me ask you this. Theoretically, if we affirmed you, this afternoon, what evaluation system is in place for Orange County School District?
Well, this is not in the record. This is like hearsay from my client telling me what's going on.
Well, I don't want to go outside the record, but as a matter of law, would you go back to what existed before 2018, or how does that work?
Yes, you would. They had a...
So if we said affirmed today, then until there's a new system
They would go
enacted
back...
by the school district, you go back to what was in effect in 2017?
Right. There was a tentative agreement in June of 2017. The union said that they violated by adding new elements, but that would be the system you go back to. I think it's already in the collective bargaining agreement appendix.
So theoretically, if you prevail, there's a benefit to you until they come up with a new system, and theoretically, if you lose, there's a benefit to them because the 2018 system's in effect immediately.
Well, they could reimpose that 2018 system, or they could...
No, but if we reverse today,
yeah.
then does the 2018 system go into effect immediately?
Well, meaning the system that was... if it was reversed today, I think it would remain in effect. I think whatever they did in May 2018 remains in effect.
So there is a practical benefit from the time of our decision until they come up with a new, whatever plan they come up with.
I would say so, yes.
Okay.
Any other questions or, okay.
Okay. Thank you, guys.
My question right out of the box is, same question I just asked, is there a practical effect on an affirmative reversal from the time of our decision until there's a new, whatever plan is adopted by the school district.
I don't think there is, quite frankly. I think, you know, the record's replete with us saying we weren't implementing the new system. We have the same exact learning map today as we had in 2018 before they alleged we made the unilateral change. So there's nothing really to change. I'd also point to you.
Well, if we reversed, what plan is in effect?
I'm sorry, I didn't
If we
hear.
reverse today, what plan is in effect tomorrow?
The system we've had since 2018.
Okay. And if we affirm, what system is in effect immediately?
The system we've had since 2018.
Why would that be?
Because we didn't change the underlying. If you look at our instructional practice manual, there's what's known as a learning map. It's the 45 elements that teachers are evaluated on. If you look at the one from 2017 and you look at the one from 2018, they are identical. There was no change. That was, if you sense some frustration with me about the lower court and the commission's factual findings, that's part of it.
But you haven't appealed those factual findings. So you took exception to the hearing officer's factual findings, and Prex said that they were grounded in competent substantial evidence under Chapter 120. I don't know what the merit of making that argument now is when you didn't raise it in your initial brief and you in fact conceded it. That's on page 11 of your initial brief. It basically says we don't agree with this, but we concede that it has.
I understand, Your Honor, and I was trying to be responsive to Judge Evander's question and asking what the practical effect was. And so when I go back to my client and say, let's say you affirm the decision, I'm going to say, I'm going to tell them the court has affirmed that we have to go back to the 2017 system, right? And so then they will look at the 2018 evaluation manual and they will look at the 2017 evaluation manual and they will see identical learning maps. And then they're going to ask me, John, what do we need to, or Ms. Palmerini, what do they need to change? That's the practicality that I was trying to address, Your Honor. That's all.
There's also a third option, the school district could come up with a different plan.
That is always something, and no, that would be outside the record, so I'm not going to say that. One other thing that I would note with respect to the notice posting, just so the record's clear, and we submitted the affidavit of Leanne Blackmore, we have already posted the notice for 60 days, from November the 1st until December the 30th. If this court were to affirm the order of PERC, I don't know what one of the things they said that we would do is post a notice. Well, we've already done that. So there's no practical effect there. I don't think that, especially given the legislative interpretation of 2524, to make us post a second notice saying we violated the law when the legislature adopted our theory would be appropriate in this case, and I would respectfully suggest that it's not. And if this court doesn't have any further questions.
Okay. All right, counsel. Thank you very much.
Thank you, Your Honor.
Thank you.
Your honors. Sorry.
Honors. All right. We'll stand adjourned. Have a good day.